we ready on R1?
No, I have the paperwork. Yep, but as soon as I get it, it's been running.
21377 is a motion to revoke unadjudicated probation. Well,
It is, Judge.
all right, what are we going to do?
We have a proposed resolution. What we'd like to do.
Welcome back to the channel, folks, and buckle in, because today's docket is a roller coaster of Texas justice. We're diving into 3 very different defendants, all under the watchful eye of a no-nonsense judge. First up, Gregorio Flores, facing a motion to revoke his unadjudicated probation for a felony injury to a child case, after allegedly getting caught driving while intoxicated. And here's the twist. Instead of throwing him straight into prison, the attorneys are pushing for more probation time and alcohol programs. But will the judge buy it? Then, we shift gears to an unlawful possession of a firearm case with a prior felony, where the punishment range suddenly jumps from 10 to 20 years. Yet the defense has a surprising deal on the table. And finally, a case of fraudulent use of identifying information, where the dispute isn't over guilt, but over exactly how much money the victim lost. We've got high-stakes, legal chess moves, and more than a few eyebrow-raising moments. Let's get into it.
And you were here with Mr. Galmore, your attorney, and the state's attorney, does the defendant. We have a formal reading of this motion to revoke unadjudicated probation, and can we proceed in summary?
Yes, Your Honor.
In summary, and raise your right hand, sir. You solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Lower your hand. In summary, this states that on February 23rd, 2015, in this court, you were placed on 10 years deferred or unadjudicated probation for injury to a child or an elderly or disabled person. So, right.
It's injuries are not deferred when they're not.
Allegation 1 states in this motion to revoke probation that you committed the offense of operating a motor vehicle while intoxicated on or about July 17th, 2024 in Jefferson County, Texas, which would be in violation of condition 1 of your deferred order, which is don't commit an offense against the state, any other state, or the federal government. Don't commit a crime. Is this allegation true and correct as it is alleged?
Yes, true.
Are you pleading true voluntarily and because it is true? Do you understand that a voluntary and knowingly made plea of true to one or more violations of probation, that is enough to grant the motion to revoke probation? Your probation could be revoked and you could be sentenced to no less than 2 nor more than 10 years confinement in prison. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. All right. Is there a formal agreement on prepared in writing?
No, Your Honor.
Well, what do y'all want to do? Read it into the record here.
Yes, Your Honor. What we're proposing is to extend probation for 2 years, Your Honor, in this case, and to add and any of the courses that are going to be required. He's going to go plead to the DWI, Your Honor. So he's going to have to take as part of that probation, he's going to have to take the courses, the alcohol courses, as well as probably the AA meetings as well. So
Is it misdemeanor for?
It is.
Yes, sir. Everybody. So we're just going to extend it 2 years from
It would be from February 25
to 25 to February 23rd, 22nd.
Yes.
2025 to 27.
That's correct.
That's the plan? Okay. If I follow that, you have no right of appeal of this decision. Do you understand, sir?
Yes, sir.
There is no writing, but I want all the lawyers to sound in agreement.
yes, Your Honor.
We don't need something memorialized in writing. We're all on board on the record as officers of the court. The defendant is sworn in. That is the plan. You want me to extend, which I'm going to do. There's nothing further to add. I'm going to find that there is sufficient evidence supporting this allegation of committing the offense of operating a motor vehicle while intoxicated. You did do that on or about July 17th, 2024 in Jefferson County, Texas, sir?
Yes, Your Honor.
All right. You're taking full responsibility for that.
Yes, Your Honor.
That's enough to grant this motion to revoke unadjudicated probation. You can be found guilty now and sentenced up to the full range of punishment for this third degree felony, up to 10 years in prison. However, what I'm going to do instead is defer any finding a violation at this time, hold it in suspense, continue this motion to revoke unadjudicated probation for 2 years from February 22nd of this year. So it'll be extended to February 22nd, 2027, if not ordered terminated before that. That's right. For good behavior. There will be additional terms and conditions of probation on this one that we want to supplement. You are going to be pleading guilty to the misdemeanor DWI case. You must follow all those terms and conditions of probation that you're going to be placed on. Is there anything in addition to what would be normal and customary in a DWI misdemeanor case that we want to add for this particular probation? You must follow all the other terms and conditions of probation that you have been ordered to follow. Okay.
Judge, just for the record, he's ordered to have an interlock device, and that would be part of this agreement is he is ordered to keep that interlock device.
Good. Well, that's a good safety. That's a good safety measure all the way around. So it's a good procedure, and that will be ordered as an additional condition of this probation in this 21377. Anything else on that?
No, Your Honor, I think we're safe.
Thank you. Yes.
Okay, he needs to come get a resetting. We can't hold it up without a future court date.
Yeah, we need to do some paperwork. If you close it, we got a problem. That's right. This plan can't work. Okay.
Judge, I do have one more if you want to bring that up now. It's Rachel Fuller.
Rachel Fuller? Here, I got one case.
Thank you, Judge. Oh,
Jarvis Starkland. We now call 25 CR 167, the state of Texas versus Jarvis Argonne. That's you, sir? Absolutely. Present with your attorney, Mr. Kimber, and the state's attorney does the defendant. We have a formal reading of this indictment here and the arraignment here. Can we?
Now, here's where courtroom watchers need to lean in. Flores admits, under oath, that he did, in fact, commit the DWI while on probation for injury to a child. Under Texas law, that admission alone could mean up to 10 years behind bars. But instead of revoking probation, the judge agrees to extend it by 2 years, tack on alcohol courses, AA meetings, and keep the interlock device installed in his car. This is a classic example of judicial discretion. A moment where the bench decides that rehabilitation might serve the community better than incarceration. But here's my question to you. Is this a second chance or a missed opportunity to enforce tougher consequences? Drop your thoughts below, because this one's bound to split opinions.
To second degree felony punishment, which carry with it a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, Your Honor, if I might just make clear, the enhancement paragraph alleging that felony conviction is not the felony conviction that serves as the predicate for the place.
Okay. Yeah, that would 1, 2, 3, 4. There would be an inability to do that, by the way. Okay. And by the way, you were here with your attorney, Mr. Kimler, and the state's attorney. I did release out the back then. An agreement has been reached in your case. You would be pleading guilty, placed on deferred or unadjudicated probation for up to 10 years in length. There's no fine. And there would be terms and conditions of probation which are normal and customary for the type of offense. Is that your understanding? If I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this indictment, guilty or not guilty?
Yes.
Are you pleading guilty voluntarily and because you are guilty? Paragraph 2, alleging that prior conviction of, in 2014 of, manufacture or delivery of a controlled substance, a second-degree felony. Is that true and correct as it is alleged?
They all are.
And are you pleading true and correct to that voluntarily? And show you here what's marked as State's Exhibit 1. I'm going to ask you, did you sign that document, understand it, discuss it with your attorney?
Yes, sir.
Is everything true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
Without objection.
Without objection, it's admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been direct to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are given up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied by the representation of your attorney. All of this is true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence this report is waived.
So waived.
If nothing further, here's what I'm going to make findings into the record, stating that, number one, you are pleading guilty. I find you are pleading guilty voluntarily, knowingly, intelligently. Next, there's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, as you have given up your rights to a jury trial and the rights to the appearance, confrontation, and cross-examination of witnesses. And furthermore, you have pleaded true voluntarily, knowingly, intelligently to paragraph 2, which enhances this third-degree felony of unlawful possession of firearm by a felon because of a prior felony conviction here as alleged to second-degree felony punishment, which is no less than 2 nor more than 20 years confined in prison and a fine up to $10,000. There's enough to find you guilty here under law and under the documents that have been entered in here. However, I'm going to follow this agreement and defer any finding, postpone any finding of guilt so long as you follow these terms and conditions of probation. You do so in time, it will be dismissed if you do well. If you fail, your probation can be revoked, and it's going to be probation for 10 years, and it could be shortened.
That's when it's,
It could be shortened if he does well. And if you fail, though, your probation could be revoked. You could be found guilty and sentenced up to 20 years in prison. Do you understand how important it is to follow the rules and do well here?
I'm sorry. Yeah. Okay. You bet.
Okay. I've signed these documents. Your future and
And that's a wrap on a triple header of justice. In just one session, we saw Gregorio Flores avoid prison, but walk out with 2 more years of strict probation and mandatory sobriety programs. We watched a felon with a firearm conviction get a shot at a clean slate. 10 years deferred, so long as he toes the line. And in the final act, Benjamin Johnson walked away with 5 years of probation and over $1,500 in restitution for fraudulent credit card charges. 3 cases, 3 very different outcomes, all under the same gavel. Each one is a reminder that the courtroom isn't just about the law on paper, but about strategy, negotiation, and the human judgment that ties it all together. If you found these decisions as intriguing or controversial, as we did, hit that like button, share your take in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Until next time, keep your eyes on the bench and your mind on the facts.
5 years.
Yes, sir.
Fined $1,000. Is there any loss here?
No, Judge.
Okay.
Actually, I was confirming that there is, and Judge, I'd like to, we're going to need to run this by the defendant. You're going to need to modify and remove the fine because there is a loss of $1,565.15. That's how it needs to be.
Replace that.
Yes, I don't have a fine if he's got an institution.
Okay. The complainant stated the total amount of charges made to her credit card was $1,565.15.
That's it, Judge. That's where I'm getting that amount from.
Is that right or wrong? That's,
No, that's the risk.
No,
Yeah.
that's what this says in this probable cause affidavit.
Yes, sir.
It says charges were made from her credit card that was inside stolen purse.
Yes, sir.
The total amount made to her credit card was $1,565.15. That's that. Is that right or not?
Judge, it was my client's understanding that he only had,
It's in the probable cause act like that.
Yeah.
So that's what it states. But
that's her total.
Okay.
what do you say?
He was not aware of it being that much, but he is fine with paying the restitution back, Judge.
Yes, sir. Without a problem.
It was originally thought there was like $22,350. Then that was reduced after they did more investigation. Yeah, that was what was suggested of the loss at the beginning. Then the police did the investigation and looked into it, and then they got it. They found the charges on the card to be that amount. So the agreement was you would also be paying a fine of $1,000. The state says they're withdrawing that, and it's going to.
Instead of,
So there's no fines, but there is restitution owed.
Correct, Judge.
The next question.
Yeah.
Does all that run thing is paid through probation?
yes.
Yeah.
Okay.
Yeah.
Paid probation.
I thought I had to pay like so up here,
No.
bought them personally. I was.
Nicer than that.
I appreciate you. So I think I should say you on my last.
Oh.
James Payton.
You got that on lawyer this time.
Oh, good.
Oh, that too. I'm getting held on this system.
I'm not gonna say that too loud.
Give me the total. It's not again, give me 1,100.
Okay. Once again, you would be sentenced to 5 years in prison. That would be suspended. You would be placed on regular probation for 5 years. Ordered to pay restitution in the amount of $1,565.15, and there would be no other terms and conditions that are normal and customary for this type of crime. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not
Guilty.
guilty? I'm sorry, we were speaking over each other.
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
Show you what's marked as State's Exhibit 1 there. Did you sign that document
Yes, I did.
voluntarily?
Yes, sir.
Understand it, discuss it with your attorney, or the
Yes, sir.
contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence and without objection admitted. Among other things, the state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with from the guidance been read to you, we've read it. You are guilty of the crime charged or any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer.
Yes.
All of this is true, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record. Any thing to add is a pre-sentence report
It
waived?
is waived, Judge.
If nothing further, I'm going to follow this agreement and find you are mentally competent in your guilty plea.
Yes, sir.
There is sufficient evidence from State's Exhibit 1 supporting your guilty plea to find you guilty beyond a reasonable doubt.
Yes.
I now find you guilty beyond a reasonable doubt of this third-degree felony, fraudulent use or possession of identifying information. And following this agreement, you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. That confinement is suspended. You're placed on regular probation for 5 years. There will be terms and conditions of probation. The probation officer will be going over with you.
Yes, sir.
Important restitution to the complainant in this case of $1,565.15 shall be ordered as part of this probation. Do you understand what has
Yes, sir.
happened today, sir?
Yes.
Okay. Good luck. Please see him. Thank
Thank
you.
you, Judge.